Mr. Murphy. All right, so I have Miss Smith, and let me call the case, and then she would like a breakout room with you. So, in the matter of the people of the state of Michigan versus Jackie Mae Smith, file number 25-22206FH. I have Isaac Sneed appearing on behalf of the people, and Matthew Murphy appearing on behalf of Miss Smith. This is date time, as I said, for pretrial. I'm going to open up a breakout room, and give me 1 second. I'm going to put Mr. Murphy and Ms. Smith in that breakout room. All right, go ahead and join that breakout room.
We do have the plea agreement. I will sign it now. Can I sign this with your name to this, Ms. Smith, with your permission?
Yeah.
I'll get this over to the court.
All right, there's no sentencing agreement.
No sentencing agreement. We are going to ask for to address bond after the pleas enter, though, Your Honor.
Ms. Smith, you're not on probation in this circuit court anymore.
No, ma'am. I'm not on anything, ma'am.
All right. So, Mr. Sneed, is that a correct recitation of the plea?
Yes, thank you.
All right, Ms. Smith, you want to raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
So you have heard the statement of your attorney. Is it your intention to plead guilty to count 1, larceny in a building, which carries a maximum penalty of up to 4 years in prison and or a $5,000 fine? Count 2 would be dismissed, as well as a habitual offender notice. So is it your intention to plead guilty to that count?
Yes, Your Honor.
All right. Are you satisfied with Mr. Murphy as your attorney and the advice that he has given you?
Yes, Your Honor.
Neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. Sneed?
Yes, Your Honor.
Mr. Murphy?
Yes, Your Honor.
And Ms. Smith, is that correct as far as you're aware?
Yes, Your Honor.
Right. So Ms. Smith, if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now. I'm sorry, to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial. And if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you might have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted and you engage in any misconduct as defined in MCR 6.310 between now and sentencing, the court will not be bound by any sentencing agreement or evaluation, and you will not have a right to withdraw your plea? Misconduct is defined, okay, misconduct is defined but not limited to absconding, failure to appear for sentencing, violating terms or conditions of bond, or the terms of any sentencing or plea agreement, or otherwise failing to comply with an order of the court pending sentencing. I'm sorry. Do you understand that if your plea is accepted, you will be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial?
Yes, Your Honor.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right?
Yes, Your Honor.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any
Yes, ma'am.
questions about the rights that I've given to you?
No, ma'am.
All right, so Ms. Smith, how do you plead to the charge that on or about March 23rd of 2025 in the city of Adrian in the county of Lenawee that you did commit the offense under count 1, larceny in a building? Guilty or not guilty?
Guilty, Your Honor.
Has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No, Your Honor.
You understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea?
No, Your Honor.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Sneed?
No, Your Honor.
Mr. Murphy?
No, Your Honor.
Ms. Smith, has your attorney promised you any particular sentence or estimated what your sentence will be?
No, Your Honor.
Is it your own choice to plead guilty?
Yes, Your Honor.
And Ms. Adams, just to note, so Ms. Smith, we are going to be sending over to the jail an advice of rights form that reiterates basically all the rights that I've just given to you, and I'll need you to sign that and they'll send it back to us, okay?
Yes, Your Honor.
All right, so Ms. Smith, on March 23rd of 2025, we're in the city of Adrian in the county of Lenawee.
Yes.
All
Yeah.
right, and did you steal money from a restaurant?
Yes, Your Honor.
What'd you do?
I put my hand in the tip jar and took $5 out.
Okay, and you didn't have permission to do that?
No, ma'am.
Were you an employee there?
No, ma'am.
All right, Mr. Sneed, are you satisfied?
Yes, thank you.
All right, has the court complied with MCR 6.302 B, C, and D? Mr. Sneed
Yes, Your Honor.
and Mr. Murphy?
Yes, Your Honor.
I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights, or her rights, and she does have competent counsel. I'm going to set this is, let's see, so I'm going to set this matter for sentencing on June 27 at 8:15. Mr. Murphy, you're available that day?
Yes, Your Honor.
All right, and
What day did you say, ma'am?
June 27 at 8:15 in the morning.
Thank you.
Before we proceed any further, Mr. Murphy, you wanted to address bond?
Yes, Your Honor. Ms. Smith, she did take responsibility today for, I mean, obviously it is a felony, but it is for taking, tips out of a tip jar. The guideline range, sentencing guidelines on this would be, 0 to 17 or 0 to 11 with an asterisk. So quite frankly, she's already been in jail now since late March, since when this happened. I would ask the court to consider a PR bond because obviously the time that she's served is something that I would say would be an appropriate sentence already. Now, Ms. Smith, I don't believe that she's a flight risk, as the court explained. It's even more now. So now that anything that she does or misbehaves between now and sentencing, it throws out everything that she's pled to, any agreement that she's had. And it's also exposed her to further charges. Ms. Smith is adamant that she would be willing to appear every day to the court or have a GPS tether. She understands that she has to abide by all the orders of the court and the bond conditions and appear for sentencing. So I would ask the court to consider a PR bond with whatever conditions the court thinks is appropriate for Ms. Smith.
Mr. Sneed?
Your Honor, the people would ask that a bond remain for Ms. Smith. This is likely a case where she's not fit for probation based upon her history, and a lengthy jail sentence will be recommended. Just like the court to consider that since 2022, Ms. Smith has had 26 cases just in Lenawee County, 7 of those felony cases. And since 2005, she's had over 31 cases in multiple jurisdictions, including Lenawee County. So Ms. Smith clearly, isn't probation material. She should serve time based upon anticipated recommendation for jail. Thank you.
All right, anything else, Mr. Murphy?
Nothing further, Your Honor.
All right. Okay, so what I would say on the first part is that Ms. Smith has failed to appear in this court before. So I do feel that she potentially would abscond again. Secondly, yes, I've had so many cases with her in the last couple of years that I think more than 30 days in jail will probably be appropriate on this. And thirdly, Mr. Murphy, I don't think to dismiss the fact that she stole tips from servers. I worked as a server through high school, college, and law school. They rely on tips. So I think it's egregious whether or not it was from a tip jar or from the till. So I'm going to set this matter for sentencing on June 27 at 8:15 in the morning. Ms. Smith, do you wish to appear via Zoom or in person?
In person, please.
Okay, we'll set that for in person. Someone from MDOC is going to come over and meet with you. Be truthful with them about your background, the events that occurred. They'll prepare a pre-sentence report. We will provide a copy to Mr. Murphy. Mr. Murphy will come and review that with you before the day of sentencing, and then we'll see you back on that day. Thank you.
Thanks.
Thank you, Ms. Smith.
All right, so. Saw Caleb Daniels. Mr. Murphy, we saw Caleb Daniels. Saw Noah Lamley, I guess we need, right?
Yes, Your Honor.
Hello, Your Honor.
Hi, so I am ready for Noah Lamley. And yeah, let me see. Yep, Noah Lamley. I got two windows open.
Yes, ma'am. Believe we have actually, you should have, was Ms. Smith the only one you had right at that moment?
Yep, I have jail Zoom 2 open and one that says public defender.
Gotcha. That was the one our female, Ms. Smith, was just in, so I will close you down out of that one, and then I can get you two. You said you wanted Lamley.
I think just right now Lamley.
Oh, okay.
I don't
perfect.
have any
Did you
other
still,
attorneys.
10 o'clock, want Mr. Rayner back?
Yeah.
Or are we waiting for your word on that one?
At 10, well, actually, before I see Mr. Raymer, I'm hoping to see Daniel Sloan
Okay.
and Castro Oliveras. So we'll start with Lamley, then Sloan and Oliveras.
Yes, ma'am. Sounds good to me.
All right, sorry, thank you.
No worries. Thank you.
I don't know.
He's so polite. He's always polite.
There's been 80% change over since I left 4 years ago. Fine.
That's Colton. He is so friendly. He is so nice. They all are, but
Of course, Joanna.
with that.
Joanna's.
I said, of course, Joanna. know.
Yeah, no, and I've never seen him. I've never met him, but I remember talking to him downstairs. And he was always so nice and friendly.
I don't think Judge is on the bench.
Still in court.
Still going?
Still in court.
You can see Brenda's in front of Judge Wilson. He's not lying. All right, Mr. Lamley?
Yes, ma'am. Can you hear me?
Yep, let me grab your file. All right, Mr. Murphy, in the matter of the state of Michigan versus Noah Lamley, we have two files, 24-22063 FH and 25-22205 FH. So both are set for pretrial. There's contempt of court that came up from district court. On one of the files, I have Isaac Sneed appearing on behalf of the people and Matthew Murphy appearing on behalf of Mr. Lamley. So, Mr. Murphy, how would you like to proceed today?
Your Honor, we're going to ask to adjourn. We're still waiting for the Forensic Center to complete their criminal responsibility evaluation. It looked like there was some misunderstanding about the previous. There was an appointment on the 18th where Mr. Lamley was in custody. So I think they rescheduled that, but they haven't come back with that, and they've completed the evaluation, but they haven't come back. We haven't gotten anything back about their assessment. So we're just going to ask to adjourn. Hopefully we get that here soon.
So what I'm going to do is set it for June 4, but obviously once we receive that, we'll bring them in right away. So I'll set this for June 4 at 8:30 in the morning. And Mr. Murphy, can you do this step in order to adjourn?
Yes, Your Honor.
All right. And Mr. Lamley, hopefully that comes in sooner and we'll get you back in here quicker. All right.
Yes, ma'am.
All right. Thank you, Mr. Lamley.
Thank you, Mr. Lamley.
She's in front of him.
Yeah, and Sam's sitting in his courtroom right now.
Okay. All right. Miss Underwood is finishing up in front of Judge Olsaver right now. So she should be here in just a moment. I have Salvatore Malaro appearing on behalf of Mr. Raymer, and I have Nick Sears appearing on behalf of the people. This matter is pending from a jury trial conviction, and sentencing is scheduled less than a month away on June 5 of 2025 at 8:15 in the morning. Mr. Malaro, we are here today on your motion for bond reduction.
Correct, Your Honor. If it pleases the court, Your Honor, I submitted my motion on April 28th, 6 days after Mr. Raymer was remanded to the jail upon his conviction. I did go and meet with him. I believe that he is genuinely remorseful for his behavior that day. I did sit in on part of the trial. He readily admitted that he was intoxicated on that day. I believe that is the predicate for what happened. If he wasn't intoxicated, I don't think that he would be where we are today. Judge Hughes County today will have been in custody of 21 days. I did just receive his pre-sentence report. I did a brief review. I believe there's I would have some issues with some of the scoring. But that would be at another day. Even under his score now, it's 0 to 17. So that does not merit a prison sentence. Based on my conversation with Mr. Raymer, I believe that he is remorse genuine for this matter. I also, as I stated in my motion, that alcohol is, I think, the underlying factor. I believe if the court considers the criteria for release at post-conviction, I would argue to the court that clear and convincing evidence exists. This is not something that occurred with the public. It was with an interaction with the police. I believe the court can put in conditions for Mr. Raymer to maintain sobriety. I'm not aware of in the prosecutor's response that he missed the court date. If he did, our office was representing him at that time. I don't know if the court issued a warrant. These matters out of Missouri are a little concerning. I don't know if 2031 CR 05183 means that's a error. Is that a 2021, 2011 case? They all seem to be minor offenses. I'm not aware of there being a hold on jail for him there. I think Mr. Raymer would like an opportunity to show this court that he can be a productive member of society and that this is just a one-off here. And we'd ask the court to consider granting him a PR bond with appropriate conditions pending sentencing. Thank you.
Mr. Sears.
Your Honor, upon reviewing everything since post-trial with Mr. Raymer, our office is not too concerned with what you rule on whether to release him or not in the sentencing matter. We do believe every justice has been served with the trial and with the guilty verdict. At that point, To point out, upon review of public court records from Missouri, I just wanted to make the court aware that it does appear that he has, it's technically 3 bench warrants for failure to appear, but 2 of those cases are the same date, time, same incident, so. And then I believe the failure to appear was at the final pre-trial in December before the original trial was set for the 26th of December. Other than that, Your Honor, the people do not have too much more to add, and we'll leave the ultimate decision of this matter at the court's discretion.
All right. So thank you. In light of the fact that you've made the court aware that there is some dispute to guidelines, this matter is set for sentencing on June 5. I'm going to order that sentencing memos be provided to the court by both sides by May 30th. So obviously, Mr. Malaro, get that out so that he can file a response, so that way I can review it before the day of sentencing. Mr. Raymer, I appreciate what your attorney is saying in his request, but having sat through the jury trial and watched the body cam and being required to hear you call police officers a fucking cunt, at least I think I lost count at 30 times. And the dangerous situation that occurred that day, I do find that your behavior was egregious, and that I do not have faith that you will not violate your bond conditions. So I am going to keep your bond or keep you remanded to the custody of the sheriff's department pending sentencing. Mr. Raymer, I will also say that you're not looking at a prison term, okay? So don't worry about that, all right?
Yes,
And
Your
then I
Honor.
want you to think long and hard. I mean, this has got to stop. All right, thank you, Mr. Raymer. We'll see you back on sentencing.
Would it be okay if I say something?
No, we're good. We'll see you back on sentencing.
Oh, yes. Thank you,
Shane,
Your
I'll
Honor.
come talk to you.
Thank
I'll come
you.
Talk to you tomorrow.
All right, thank you, sir.
All right, thank you. Ms. Underwood, in the matter of the people of the state of Michigan versus Delshon Bomarito, file number 25-22196FH. Ms. Underwood represents Mr. Bomarito. Mr. Sneed represents the people. Ms. Underwood, how would you like to proceed today with Mr. Bomarito?
If I could just talk to him for half a second, Your Honor.
Yep,
You've
Mr.
spoken,
Bomarito, we have really good audio on today, so that's a good thing. So I'm going to assign Ms. Underwood and Mr. Bomarito to a breakout room. Mr. Bomarito, I think you'll go automatically and then I'll bring you back. But if you don't go automatically, someone might have to do it for you. Yep, he went automatically. All right, Mr. Lee, you'll be next. Thank you. All right, takes a couple seconds. All right, Ms. Underwood, how would you like to proceed with Mr. Bomarito?
Your Honor, the plea bargain offered to Mr. Bomarito is that Mr. Bomarito would plead guilty to count 1, assault of a prison employee with 1 supplement, Your Honor. Count 2, and the remaining supplements would be dismissed. We would also be asking at this time for a COBS to the low end of the guidelines, Your Honor.
All right, any, is that Mr. Sneed, a correct recitation of the plea and any position on any COBS to the low end of the guidelines? You're muted, sorry.
That is a correct recitation, and the people defer to the court's discretion regarding the sentence.
Okay, thank you. All right, that's fine, Ms. Underwood. So is your, and your client's gonna avail himself of that plea?
He will enter that plea today, Your Honor.
All right, so Mr. Bomarito, want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, I do, Your Honor.
All right, and Mr. Bomarito, or Ms. Underwood, with 1 offense notice, that would make it a 7.5 years, is that what that is?
I think it's
With one sup, what would be the maximum penalty, Ms. Underwood?
I think it's 6, Your Honor.
Well, it's a 5-year felony.
Okay, then, yeah, I do think 7.5.
Okay.
Yeah.
Okay, all right. So Mr. Bomarito, you've heard the plea offer that was placed on the record today. Is it your intention today to plead guilty to count 1, assault of a prison employee with 1 habitual offender supplement, which would make the maximum penalty up to 7.5 years in prison and or a $2,500 fine, with a COBS agreement to a sentencing at the low end of the guidelines, whatever that might be? So is it your intention to plead guilty to that count today?
Yes, Your Honor.
All right, are you satisfied with Ms. Underwood as your attorney and the advice that she has given you?
Yes, Your Honor.
All right, neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court other than the court will COBS to the low end of the guidelines. Ms. Underwood, is that correct?
That's correct.
Is that correct, Mr. Sneen?
Yes.
And Mr. Bomarito, is that correct as far as you're aware?
Yes.
All right, sir, if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Mr. Bomarito, do you understand? Let me go back there. Do you understand that if the plea is accepted and you engage in any misconduct as defined in MCR 3.10 between now and sentencing, the court will not be bound by any sentencing agreement or evaluation, and you will not have a right to withdraw your plea? So do you understand, Mr. Bomarito, if you commit another assault of a prison employee and are charged with offense, I will not be bound by that COBS agreement anymore? Do you understand that?
Okay.
They changed the law on that. So it used to be if something happened and the court wasn't going to honor a COBS or a Killebrew agreement, you would have the right to withdraw the plea. But the legislation has changed that now, and you wouldn't have the right to be absconding or failing to appear for sentencing, which isn't going to happen in your case, and violating conditions of bond or terms of sentencing. So basically, if you were to get another charge, that could be a violation of whether or not I COBS you to the low end of the guidelines. Do you understand that?
Yes, I do.
Okay, do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that, Mr. Bomarito?
Yes, I do, Your Honor.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Ms. Underwood?
No, Your Honor.
Mr. Sneen?
No, Your Honor.
Mr. Bomarito, has your attorney promised you what your sentence will be like in terms of guidelines or the minimum sentence?
No.
Okay, and it's your own choice to plead guilty?
Yes.
And you're satisfied with her as your attorney and the advice that she's given you?
Yes, Your Honor.
All right, so Mr. Bomarito, on October 5 of 2024, were you at the Gus Harrison facility located in Lenawee County, Michigan?
Yes, I would.
All right, would you agree that that facility is located in Madison Township?
I believe it's located in Adrian.
Well, we call it Adrian, but it's actually located in Madison Township. Would you agree to that?
Yes.
Okay, and you were an inmate at that time at that facility?
Yes.
And you had been sentenced and you were serving a term there, correct? So you were lawfully imprisoned?
Yes, Your Honor.
All right, so at some point you came in contact with a Joshua Treyfry, who was an employee there. Was he a CO or was he a custodian? Like, what was his job there?
He was a CO.
Okay, and did you assault him in some way? Did you push him, pull him, kick him, punch him, spit on him? Tell me what you did.
I punched him, Your Honor.
You punched him? Okay. And you had no right to do that, correct?
No,
Yes.
no, Your Honor.
Okay, thank you.
Okay.
I swore you in, right, Mr. Bomarito?
Yes, you did.
Yeah, I did.
Okay.
Yeah, I did. I thought I did. Okay.
Sorry, Judge.
All right, Mr. Sneed, are you satisfied?
Thank you, Judge.
All right, has the court complied with MCR 6.302 B, C, and D? Ms. Underwood
It has.
and Mr. Sneed?
Yes, Your Honor.
I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. Other than the Cobb's agreement to the low end of the guidelines, this court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the Michigan Department of Corrections for a pre-sentence investigation. So, Mr. Bomarito, you're going to get a packet. Someone's going to talk to you. They're going to prepare a pre-sentence report. Be truthful with them about your background, the events that occurred. They'll also look at your prior pre-sentence report. Ms. Underwood's really good about meeting with people within MDOC before sentencing, but sometimes MDOC won't let her schedule because they have other conflicts going on. So if she can't talk to you in advance, I will give her an opportunity to speak with you that morning. Ms. Underwood, are you available for sentencing on June 27 at 8:15 in the morning?
Yes, I am, Your Honor. Mr. Bomarito is at Ionia, where they actually do let me schedule telephone conferences, Your Honor.
So Ms. Holly, he's at Ionia. All right, Mr. Bomarito, you do have a right to be present in person for sentencing, or you can appear via Zoom. What would be your preference?
I would appear via Zoom.
Okay, I promise you we don't have as many cases on sentencing day, so it won't take as long. All right, so we will see you back via Zoom on that day for sentencing. And Mr. Bomarito, thank you for your patience this morning, and I'll see you back on that day. Thank you.
Can I ask you one question?
Sure.
Did you accept the Cobb's agreement or that's?
Yes, she did.
I'm gonna send you to the low end of the guidelines, whatever they are.
Okay. Thank you, Your Honor.
Thank you, Mr. Bomarito. You have a good day.
So,
Okay. Mr. Lee is next. So let me grab his file, put Mr. Bomarito's away. Okay, this is.
Courtrooms aren't just about punishment, they're about choices, consequences, and second chances. Today's hearing showed how a single guilty plea can change someone's future in ways most people never realize. If you enjoy real courtroom breakdowns, legal insights, and the moments that happen after the cameras start rolling, make sure to like this video, subscribe to the channel, and turn on notifications.